Hello, everybody. Welcome back to your favorite lunchtime webinar for landlords. I am here with Dan Hayes with Real Property Management. Dan, you want to say hello to everybody as they pile into the room?
Good afternoon, everybody. Great to be here.
If you don't know who we are, my name is Ben Ficker. I'm a multifamily broker with Equity Pacific Real Estate here in the Portland metro area. We are very good at what we do, and our whole goal is to provide, Dan Hayes, I'm speaking for Dan, you're here with us too. Our whole goal is to provide you with so much value in these webinars that when the time comes for you to make some decisions around your investments, that you at least give us a call and we have a chance to discuss what we can do for you. Dan Hayes runs Real Property Management Solutions. He is the guy that I refer everybody to. I don't know anybody who knows this stuff as well as Dan. That's why he is my my co-pilot on this stuff. So while we've got some people still piling in, I'm going to put a little poll up. Before we jump in to the details, I'm going to ask a question. I'm going to leave it up for about a minute. It really is. Oh, sorry, showing the wrong screen here. Let me get out of there. Man, you'd think I'd never done this before. Let's hold on. Dan, can you see the poll?
Yeah, it says, do you feel confident in your ability?
We are getting responses. Gotcha. It's not showing up on my screen, so I didn't know what was going on there. So, and the question is, do you feel confident in making decisions around the legislative changes that are going on? I love to see that we've got 80% in there. I know you all feel that way because you've been coming to our webinars. So I can tell you, we talk with a lot of people. I talked with an out-of-state owner today who mentioned he wants to get his property on the market, mentioned he was going to issue a 30-day rent increase notice. And I was like, hey, what are you doing at noon? You got to jump on and talk with us because that's not going to be something you can get away with. So, all right, we're up for a minute. 83% say they're confident. That is wonderful. Let me get my slides back up. So that's a good primer for where we're at, although that might change once Dan talks about the new changes. So, all right, we've been running for a couple of minutes. Let's get going here. We're going to do a quick introduction, which we've done. As the multifamily broker, I'm going to tell you about how these legislative changes are affecting what I'm seeing boots on the ground. Dan Hayes is going to talk about these new recent changes that he informed me of that I didn't even know I had to be aware of, and now we are. I'll give some final thoughts, and then we've got our question and answers. Again, if you're new to our webinars, use the question box to answer those questions, and then we'll kind of batch them together as we get to the question and answer. So I'm a multifamily broker with Equity Pacific Real Estate. Been doing real estate since 2004, multifamily specifically since 2015. I've had an incredible wife since 2017. My wonderful son Max since 2019, and known Dan, I don't know, 10 years, a long time. We got a great working relationship. So, all right, here's some quick thoughts on what we're seeing in the market from the buyers and sellers. I'm getting quite a few more unsolicited calls from sellers looking to do something, right? Now that the eviction moratorium is out of the picture, people feel a lot more confident in their ability to sell their property and get out of town. And at the same time, we're seeing an uptick, especially in owner-occupant deals, because they feel like they can actually get into the property, and if there's a tenant not paying, they can actually do something about it now. So although we've been very robust the last few months, I'm definitely feeling a lot more people interested in doing something now. so the main point is right there on the screen. Rent increase notices need to go out now. If you have not been, I know there were a lot of people who knew their rents were under market, but didn't want to issue those rent increase notices because that might tempt their tenant into not paying rent while they had those protections. That stuff's gone now. You got to get your rent increase notices out. Dan and I have something to talk about towards the end of the webinar, but there's the amount that you're getting in rent does more than just affect your monthly cash flow, and we're going to talk about that a little bit later on. But Dan, they're here to listen to you and get filled up with all that info you've got on the rent increase notices. So why don't you go ahead? Do you want me to share your screen?
Please.
Perfect.
And as Ben is doing that, I will say this, gang. If you haven't looked at the recent rent increases that are happening, or excuse me, if you haven't taken a look at, Ben, can you see my presentation screen, or is it presenter slides?
It's showing the ones with your slides and the next slide and all of that.
Okay, let me get out of that. How do I share my screen again, Ben? How do I do
that? Go up to view up at the top of PowerPoint there.
View.
Or sorry.
Yep.
Slideshow.
I need to reshare my screen for number 2. Let's see. Let me see, because I'm not super. Okay, show my screen. Stop showing my screen. Oh, let's see. Okay, can you? Hopefully you can see my screen now. Is that right?
It's still showing the PowerPoint
okay.
As if you're editing it. It's not showing the full
thing.
Right.
I'm going to, if it's okay, I'm going to leave it this way just because it's easier. All right. So very quickly, gang, before we begin, rent increases. When you think about rent increases, know this: we are seeing unprecedented, and I really do mean unprecedented rent increase nationally through August, up 13%. Most cities that were significantly below rent are now back up above pre-pandemic levels. Some areas, year to date, for example, Bend, Oregon, 35% above prior year to date, 35%. Most of our Portland metro area, not the city of Portland, but surrounding area, are up double digits year to date. So now's the time to look at your rents for sure. And keep in mind, if you're way below market, September is the month that the Bureau of Labor Statistics will reissue Oregon's inflation rate or CPI rate. So that 7% plus what's currently 2.2, we expect that to be higher than that for the 2021-2022 period of time for statewide rent control. So just some things to think about. All right. Just a heads up as I go through this. I have no idea where you're at with your portfolio. I don't know if you manage it yourself or you have somebody else manage it. I don't know any of that. So what I've tried to do is give you a sense of what Senate Bill 278, 292, and 291 means to you. I will tell you, I've got a lot of content here. I'm going to march forward pretty quickly and purposefully, but I promise you, you will get a sense of what you're up against. And my goal today is to not give you a complete exhaustive description of these 3 bills, but to give you enough so that some sort of a trigger happens for you that says, okay, I need to dig deeper into that subject, or I need to ask some questions in that area to make sure you're in good shape. Our business, meaning the management business, has never been more complicated. Honestly, it's easily double the workload for us as property managers right now because of that complexity. So let's try to untangle that to some degree, starting with my disclaimer, which is not legal advice. Please get an attorney. I'm giving you this information. It is just information. It's not guaranteed, but please make sure you do what I do and get yourself a good attorney. As Ben said, we're Real Property Management Solutions. We manage properties across the 4-county area, single family all the way up to mid-market multifamily. And then if you want the copy of the presentation, you can see my personal contact information is. And as always, just give me a call. I've got a couple of partners in crime that can help as well if I'm not available, but I pick up my phone. I'm happy to help in any way that I can. All right. A quick refresher. Number one, let's not forget, yes, the eviction.
Real quick, Dan. Can you click give me keyboard and mouse control?
Yeah.
Because your slides aren't updating with what you're talking about. So let me get that. If you give me control, then I can take over and get that going for you.
And are you going to advance the slides for me, Ben?
Yep, I'll do that. Here, why don't we do this? I'm gonna take control real quick and show my screen. And now I'm going to change it back to Dan Hayes.
I apologize for that, King.
Okay, I just hit request keyboard control, so go ahead and hit OK with that.
Do you have it?
Yep, looks like I do. So let's. I'm going to do this. I'm going to end slideshow. Well, actually, no. We'll leave it right here. So at this stage, you should be able to. Perfect. Okay. So you can take back control now and adjust, but this is now we're showing what the slide you're talking about.
Perfect. Thank you. All right. Can you see my House Bill 4401 slide, Ben?
Yep, we're good.
Thank you. Again, apologize for the technical difficulty. Very quickly on 4401, effective, essentially the eviction moratorium is over. You can now evict tenants for non-payment of rent, for rent that is owed to you from July. We're going to talk about when that isn't the case, but officially the eviction moratorium is over. We're now in the grace period that goes until February of 2022. Remember, for any money that's owed to you from that emergency period, you can't evict, you cannot issue a termination notice, you can't charge a late fee, you can't threaten to possess. Secondly, LCF, the Landlord Compensation Fund, for those of you who applied like myself, you should now be, it would be a cause of concern if this wasn't the case, but you should now have received at least 80% of everything that you've applied for. It's unlikely that you've received that additional 20% that is coming back to us without any additional work, but you absolutely should now have received 80%. Also know that until March of 2022, remember 4401 stated that you cannot issue a 3-day termination notice for non-payment of rent during that grace period. It's now either a 10-day notice or 13-day notice, depending on when you typically issue your notices to vacate or in a tenancy based on non-payment. So if you issue a non-payment notice on the 8th day, it's not 72 or 3 days, it's now 10. All right. So make sure you get a new notice there. Don't issue any 3 days for non-payment of rent. It's either 10 or 13. That's all under 4401. That will end March 1st of next year. Let's start with probably the easiest of these three legislative bills that passed, really most of them at the last minute, and that's 282. Now, if you're managing your own rental properties or you have someone privately doing that for you, this is important for you to know. 282 did two things. It changed some of the elements of screening and how we consider non-tenant guests. So what's that mean? In an attempt to increase the ability for people to live together during the pandemic or share households, 282 did this. It basically defined this non-tenant guest as someone who's not a roommate. They're not being asked to be added to the lease. They are temporary guests of your tenants. Now that's not unusual. Here is what's different. You cannot assess a fee or terminate a tenancy based on the fact that your tenants have brought in non-tenant guests, so long as they're not exceeding the maximum occupancy guideline or state law. So we all know that the maximum occupancy guideline is typically 2 people per bedroom plus 1. So a 2-bedroom house, that means 2, 2, and 1 for a total of 5. That's the maximum number of occupants. We all have leases that talk about guests only being able to stay for a certain period of time. Well, here's what 282 does. Number one, if you have a tenant who says, I'm bringing in non-tenant guests, and that lease says that you cannot be there for longer than 10 days, that goes away, so long as they're not exceeding that maximum standard I just talked about. That means you cannot assess a fee to them. You can't evict them for occupancy. You've got to allow those non-tenant guests to be in place until March 1st of next year, so long as they're not exceeding that standard. Here's what you can do. You can screen those non-tenant guests for anything other than credit and income. So in other words, you could do a criminal background. You can request and require that those non-tenant guests enter into a temporary occupancy agreement. There are many of those forms available out there, Multifamily Northwest being one of them. But you cannot require that that temporary occupancy agreement ends before March 1st, all right? You can assess a fee for anything around conduct. You can also end the tenancy based on failure to comply with your lease, all the things you normally can do, okay? You can also accept a payment from a non-tenant guest and not make that non-tenant guest an actual tenant, all right? So if you've got a situation where somebody's got non-tenant guests that are there and you think you've got rules in your lease around the number of days, 282 says otherwise, but there are some things you can do to control that. Now, the second thing that 282 does is it really restricts now what landlords can consider for all of Oregon when they screen prospective applicants. And here's how that works. Number one, if you have an applicant who has an FED, an eviction, that arose between April 1 of 2020 and February 28th of next year, you cannot consider that eviction. You also cannot consider any unpaid rents, including anything in a judgment that happened between April 1st of 2020 and February 28th of 2022. That stays in place until January 2nd of 2028. The other thing that 282 does is it allows tenants to set aside an FED. So if a tenant was evicted during that period of time between April and February of next year, and they request that that motion be set aside, the judge will grant it. And then finally, you cannot cause any unpaid rent to be reported to a consumer credit reporting agency. Okay, you cannot do that. You also cannot tell your prospective landlords that call you for a reference that your tenant owed you money during that period. It's the same thing as reporting it to a credit reporting agency. And make sure that if you're using paper applications or using Zillow applications, which I think is a bad idea, make sure you have the right application, because Senate Bill 282 changed the language in the application such that it reflects this in the actual application. So if you're using old forms, get new ones. I've included a link to the Multifamily Northwest application here. So that's 282, non-tenant guests and application screening around FPDs and non-payment during that April 1 through February of 2022 period, and you can't report to a credit reporting agency. All right, if you've got a question on that, throw that in the question section. Let's talk about Senate Bill 278. Now, Senate Bill 278 is not necessarily an eviction moratorium. It's more so what's considered to be a safe harbor. All of it designed now for folks to have enough time to get support out of the Oregon Emergency Rental Assistance Program, OERAP we call it, to get money to the landlord. That's what 278 does. But it does more than that I really want to make sure you're aware of. Number one, if you are like us and you have been sending balance reminder statements out, this Senate Bill 278 language needs to be in that balance reminder statement. So make sure you get a new reminder statement. If you are like us and you are sending 10-day non-payment notice to end the tenancy, you need a new form because it includes language from 278. We started sending 10-day notices to end the tenancy for non-payment starting in July. We did it in August, and we're doing it now in September. Now, of course, September is far fewer than July because everybody's either given us their application proof or have paid, but we are ending tenancies for non-payment and making sure that you use these forms because you've got to have that language from 278. If you don't do this right in 278, it's expensive. 3 times the monthly rent, defense to an eviction, you'll get actual damages and attorney fees paid by you. So new forms, please. Now, 278 did this. Remember under House Bill 4401, the tenant really didn't need to do anything. They didn't need to declare. They just basically didn't have to pay rent, and you couldn't evict. 278 is different. Starting in July through the end of September, if a tenant can't pay rent, they have to provide you, the landlord, with some sort of documentation that they've applied for assistance. But that documentation can be a paper copy, a screenshot, anything else that a reasonable person would be able to say, yes, I can see that this tenant submitted for support. I have a property that the tenant did not pay in July. I have an application proof. I've got a screenshot of an application. I now have to wait 90 days. I have to give this tenant safe harbor. Interestingly enough, they did pay in August and they did pay in September. So documentation has changed for 278. The definition of non-payment has also changed. Remember under 4401, it was called the non-payment balance, which is really rent, not late fees, not utilities, not any of that. But 278 is different because now non-payment is any payment that is due to the landlord, including things like late fees, parking, storage, utilities, because the tenant can submit with OERAP for that money. And those fees obviously are in Chapter 90 and typically part of every rental agreement. So non-payment balance is different now. It's called a non-payment and includes things that 4401 did not. So let's talk about 278 in terms of what you can't do, what you can do, and what you must do. So what you can't do is, if that tenant submits documentation, you can't deliver a termination notice for non-payment rent. If you don't have an application, you can't. Just talked to a landlord just a minute ago. Tenant did not pay for September. It's time now to issue a non-payment notice to vacate. The question was, can I do that? And if the tenant submitted an application proof, you couldn't. But because this tenant didn't, they can absolutely end the tenancy for non-payment of rent. Okay. What you can do is you can now apply for the Landlord Guarantee, the LGF, Landlord Guarantee Fund, if the period of time in that application has passed. So typically outside Multnomah County, it's going to be 60. 278 says 60 days. If it's in Multnomah County, it's 90. Whichever it is, it's either 60 or 90. If that amount of time has passed and you as a landlord have not received any money, you can go ahead and apply for that rent and any of those payments I've described in Chapter 90 out of that Landlord Guarantee Fund. Okay. And for those tenants who gave us application proof in July and we haven't received any money, now is the month where we'll start to have landlords apply, or we will apply for the landlord into that Landlord Guarantee Fund. So if you don't know anything about that, please check out the Landlord Guarantee Fund, because that is something you can do. You must, if you are going to end that tenancy, if you're going to give a non-payment balance, if you're going to give a court summons, you must absolutely give that tenant notification of their rights under Senate Bill 278. And if you don't, your attempt or your effort to evict for non-payment will disintegrate. I know somebody who did not include the notice of tenants' rights and they absolutely had their eviction fall apart. And here's what that looks like. It's very simple. But if you're going to end the tenancy in that example, for September, those non-payment tenant termination notices we're sending out, we're sending this form with them. And I've included a link to that. So again, please make sure that this statement of tenants' rights goes along with that documentation, or your eviction will fall apart.
Real quick, Cecilia, I believe that answered your question. Really great timing. But if that doesn't clarify it for you, feel free to ask another question.
Yeah, and Multifamily North has a really good 10-day notice that has this language. They also have a separate notice of tenants' rights form. If you've got a different form that you're using, just make sure, please, that you include that tenants' rights, because it'll just absolutely, there won't even be any question. Your effort to evict will go away. All right. Now, some actions to be aware of. If you violate this law, the tenant obviously can get an injunctive relief to recover the possession. So in other words, they can get that property back. They also have a defense now for that possession. So it doesn't really matter. If you violate this law, no matter the situation, they will have a defense. Okay. I've talked about this this Landlord Guarantee Program. Home Forward is going to be the one that launches it. we're already receiving payments from tenants who applied for the OERAP, and we're now starting to submit applications for tenants who did not receive funding from OERAP into this Landlord Guarantee program. And here's what it is. So it's not the LCF, it's the Landlord Guarantee program. It reimburses landlords who are eligible for any costs that they incurred during this safe harbor period, as determined by Senate Bill 278. There's a portal. Here's the link. It's not OHCS now. Remember, LCF was OHCS, the Oregon Housing and Community Services, I think it's called. This is Home Forward. And that's good news for us landlords, because it's going to be much, much faster. Here's a link to the portal. There are some guidelines on the portal. I've included some links to that for the release from Home Forward, as well as some FAQs. It's not overly complicated. It's not like the LCF with the big rent roll and the prioritization and all that good jazz. But if you've got an application that you've received, you've provided safe harbor, it's been more than 60 days outside Multnomah County, you haven't received funding from Home Forward, you absolutely can apply for this Landlord Guarantee program. And don't wait too long, because I know landlords who've already received support for tenants who applied in July and August. All right. So if you know the fact that that tenant applied and you haven't received any money at all, chances are they did not get approved, or they ended up not submitting it, or whatever the case may be. You have a resource to go to, and that is the Landlord Guarantee program. All right. So that's largely it on 278, and I know I've gone through those pretty fast. Again, Ben will provide you a copy of the presentation, I'm sure. But if anything triggered you and you need more information, feel free to give me a call or get help from your local resource. All right, let's talk about 291. This is one I called Ben and said, Ben, we have got to get in front of folks and let them know that 291 is headed their way. 291 are some changes that have taken place now in the way in which you screen prospective tenants. First, understand this is not just Portland. I'm not talking about Portland's fair ordinance. That's still in place. But what you'll see, if you don't know about 291, what the state of Oregon did is they pulled a few things out of Portland's fair ordinance and applied them to the entire state. So 291 applies to wherever a rental property is in the state of Oregon, not just Portland, and it's effective January 1st of 2022. And essentially, it talks about screening procedures and disclosures to applicants, and get this, gang, it requires an individualized assessment before you deny an applicant when you're going to disqualify them for criminal convictions. For those of us who operate rental properties in Portland, we know that if we set our own screening criteria, we have to do an individualized assessment against really the 4 buckets of screening criteria, whether that be credit, criminal, income, or landlord references, if we choose our own criteria. In Portland, as you know, if you choose the low barrier threshold, the only area that you would need to do an individualized assessment is if you denied for criminal when the tenant or prospective tenant provided supplemental evidence. Well, guess what, gang? That's now going statewide. All right, and I'll talk about a few of those details. Screening charges have also changed. Now, I can't give you what your number should be, but the effective January 1st, how much you can charge an applicant for screening cannot be greater than the landlord's average cost or the customary amount charged by a tenant screening company or consumer credit reporting agency. Yes, that's complicated. What's that dollar amount? We'll have to do some math between now and January 1. Okay, it can include the tenant screening company or consumer credit reporting agency and the reasonable value of any time spent by the landlord or the landlord's agent. Here's my recommendation. Find out what folks like what we're doing. Perhaps reach out to Multifamily Northwest or Rental Housing Alliance of Oregon and see what their recommendations are, because they'll do that research. Just be aware there are going to be people out there looking for people making a mistake here. So screening charges have changed. or they will change January 1st. There are now new screening criteria disclosures. So Portland's Fair Ordinance has addressed this for what's, I think, a couple of years now. But your screening criteria has to include, I'm not talking about the application now, it's got to be on that application too, but your screening criteria that we're all required to publish has to have language around the right to appeal a negative determination. All right. You also have to have a non-discrimination policies required by federal state law, blah, 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 including that you may not discriminate against an applicant because of race, color. So that's got to be included into your screening criteria disclosure. So essentially, right to appeal, and by the way, fair housing federally, fair housing in Oregon has to be on your screening criteria. So if you have that, if you're managing those properties yourself and you're advertising to the public, your screening criteria needs to change. Ben, do we have a question?
Not yet.
Okay. So now there are some new limitations on screening requirements, all right? First of all, when you evaluate an applicant, you may consider a previous arrest of an applicant only if it resulted in charges for criminal conduct that are presently illegal in Oregon. You can interpret that the way you want. And the applicant has to be convicted of the charge, or the charges are pending and the applicant is not presently participating in a diversion program or a deferral judgment program. So those are your limits on criminal. How long you take to respond to applicants that you've screened now is mandated by the states, 14 days. So in other words, if you receive an application from an applicant, you've got to provide a written statement of one or more reasons for the reasons you've denied them under the landlord screening criteria within 2 weeks of that denial. You don't have to include the screening company, name and address of the screening company or consumer credit reporting agency that provided that report by which it's denied, and you do not have to disclose the results of that applicant screening, okay, based on that. Right? But you've got to get back with one or more reasons why you denied them. There are rules around credit reporting, disclosures, et cetera, Please know them if you're doing your own screening. Now, in your statement of the reason for the denial, it has to contain the following information: the name and address, okay, of any tenant screening credit company or credit reporting agency that provided a report. So you don't have to give the credit report, but you have to give them the name and the address, okay? You then have to acknowledge that you received supplemental evidence, if you did, and why you still denied that applicant based on that supplemental evidence, and why it did not adequately compensate for the factors that informed the landlord's decision. You also have to make sure that in your denial, the tenant has a right to appeal that determination.
Dan, can I ask a quick question about that specifically? If you've got 5 applicants, first one is denied and they've got the right to appeal, can you move on to the next applicant, or do you have to? Okay.
Yeah.
Okay.
My understanding is yes. Now, a whole gaggle of attorneys are going to sift through this, and I'm sure they're going to come out with all their statements. But so certainly wait. I'm giving this to you now because we've got a few months to kind of get our act together. But we've been doing this in Portland. For those of us in Portland, we've been doing this for a while, so it's not new news. Again, I'm not an attorney, but the amount of exposure you have now has gone up significantly, because it's this reason for denial, this statement of denial, where you can really get picked apart. So if you're doing it yourself, stop and find a screening company to help you. If you have to deny, find an attorney who will help you with that statement of denial, because that's where I think the risk is. That is what we do, and that's what most everybody else is doing. So portions of Portland's Fair Ordinance are now going to hit all of Oregon. And if you own rental properties in Oregon, and this is not for you, I have a feeling Ben's phone is going to ring a couple of times. All right. Now, this individualized assessment, for those of us important, this is not brand new. Remember, an individualized assessment is required before denial if you're denying based on criminal history. If you deny based on that criminal history, the tenant has to have an opportunity to provide you supplemental evidence to explain, justify, or negate. What would that might look like? Let's say that you don't allow any misdemeanors under 3 years. You get an applicant, they have a misdemeanor, it's a DUI. And it's a year ago. They successfully completed the diversion program, and they provide you documentation that says, hey, I successfully completed diversion. Let's say they add to that a letter from their diversion facilitator that says, Dan was the best ever. And I give that to my prospective landlord. If that landlord denies me based on that history, that landlord's going to have to say, why is that? And they have to consider in their supplemental evidence assessment, nature and severity of the incidents that led to that denial, how many and type, how much time has passed, how old the person is. Sounds familiar, doesn't it? Sounds really familiar as to how the Portland Fair Ordinance is written, because this is the same exact language. Okay. Make sure that you're using the right forms, get these changes in place. I encourage you to read the bill in its entirety. So that's Senate Bill 291, and it's headed our way. Again, 30 minutes, 25 minutes of a pretty high level, 3 complicated bills. Senate Bill 291 is headed your way. And I'll end it with that.
Perfect. So while we wait for questions to come in, I just want to give my final thoughts on this stuff. So whether or not you think that the local or state governments are on the right track with this stuff, the reality is that it is harder to be a landlord now in Oregon than it has anywhere else. There's that stupid saying, what happened in Vegas stays in Vegas. Well, what happens in Portland seeps out to the rest of the state within the next couple of years, right? So Portland tends to be the testing ground for what ends up going statewide. So if you have this idea that if you've been owning properties for 20 years, you have to completely change the way that you do your business. You can't just keep your notes on your yellow legal pad. You can't just say, this one had a nice smile, I'm going to pick him. Like the penalties for not staying in compliance with this stuff is just through the roof. Now, I want to caveat that with, I still think Portland is a great place to own property. We own property in Portland. Dan owns property in Portland. As long as you have the capacity to deal with these changes, I don't just mean financially, I mean energy-wise and time devoted to staying on top of this, then keep owning in Portland, right? So where I was going was, it is very difficult to be a part-time landlord in the Portland metro area without running into some potentially expensive pitfalls, and you cannot claim ignorance. You can't say, well, I just didn't know. You still are going to have those penalties coming your way. So if you're looking to sell in this market, interest rates are still driving demand across all asset types, whether it's 2 units or 50 units. Interest rates are still driving that. We've seen some softening we're not seeing 15 offers on a property right away, but we are seeing things still going at for stabilized properties in the 5 to 5.25 cap, still very good historically for owners, right? And that's kind of what we're seeing in this market. If you own small plexes, you have the added demand from owner occupant buyers. As long as they don't have a single family home to buy, they're going for the small plexes. Now, if you're looking to buy, I would still encourage you to buy in Portland, A, if you've got the capacity, but B, there's a lot of frustrated owners out there who are not up to date with all of this stuff, and they're looking to make deals and they're looking to get out of town. If you're looking to exchange, then you want to take advantage of interest rates while you can and lock up your up leg with these low rates and take advantage of landlord-friendly markets. Here's a quick example. We helped some clients buy a portfolio of new construction duplexes just outside of San Antonio last year at roughly $375 a door. This year, those same exact properties are selling for $450. So this is historically a market that sees 3% annual growth, you know, and they went up 25%, whatever the math is. They went up quite a bit, 20%. So finally, I am a proponent of investing in Portland. And if you are staying here, I want to emphasize that if you don't have a professional management team built in around your business, it's time to do that. It is time to take that off your plate, take that liability off your plate, and give it to somebody like Dan Hayes. The pitfalls they're just too much. As a quick example, and get your rents up. Get it to professional management and get those rents up. You have to offset the liabilities and the potential issues that you're gonna see coming from all these legislative changes. Quick example, we just closed a deal out in Beaverton. We had a tenant agree to a cash for key scenario a week before close, said, never mind, I'm not moving. I signed this under duress. She didn't sign under duress, but she decided she wasn't gonna do it. So we had to put our negotiating skills together. And really what it came down to is, we're gonna pay an attorney to get you out, or we're gonna pay you to get out. What would you like to do? She ended up getting out a few days late, got her money and moved on. But the point is, tenants are feeling a little more emboldened to play hardball in how you get them out of those properties, if and when you need them out of those properties. So if you've got questions, please throw them in the question box. But what I really just want to stress is, if you're not treating your investments like a business, it's time to do that. Whether it's with Dan, whether it's with a different property manager, whether you talk to me about buying or selling, whatever it is, we're here to give you value and help you navigate what's coming, you know, what's been coming and what's coming down the market. So while we wait for some more questions, I want to throw out another couple of polls. One, with the end of the eviction moratorium, are you more likely to send out rent increase notices at this stage? I know that there were a lot of owners who were waiting to see, you know, they didn't want to give that notice because they were afraid the tenant would then decide to not pay, and then they're stuck, right? So with the end of the eviction moratorium, are you more likely to get those rent increase notices out? All right, we are about 30 seconds in, and I like this answer. The answer is yes. 88% of you feel more confident in your ability to get those rent increase notices out.
I would also say to you, if you have rental properties in Multnomah County, do some quick math as to what this November and next November is going to look like, given everything that we passed last November.
Absolutely. Yeah.
Honestly, it's pretty dramatic, the amount of property tax increase we're going to get.
Yeah. Next question, following up to, are you going to send increase notices out? Do you feel confident in the process and details of raising rents, not just in Portland, but in Oregon, right? There's a lot of changes going on, a lot of disclosures going on. As I mentioned before, on my way to the office this morning, I got a call from an out-of-state guy, great guy, saying he's going to give a 30-day notice to his tenants to raise rents. I had to say, no, you're not. You know, let's talk about it first. So, do you feel confident, not just in the process and in the disclosures around that, but do you know what you can raise your rents to? Do you know what those caps are? Do you know what that market, when I say process, I don't just mean here's the notice. I mean, have I done my research on what actual market rents could be? We're dealing with somebody right now who wanted to get their rents up to market rent, or to market rate, which he thought was about $1,200. Reality is it's more like $1,500 to $1,600, right? But if you're not doing that research, do you really have the process and details lined up in order to get that done? We're going to close this poll. Thankfully, a lot of you say, yes, you are confident there. That's wonderful.
Ben, I want to jump in real quick on that. If passing utilities on to the tenant is going to be part of your overall revenue strategy for the remainder of the year and into 2022, please make sure that you find a class from someone like Multifamily in Northwest as it relates to passing utilities on. There's an attorney in town here who has figured out that a lot of us were not doing that properly, he has now had a great year and been very. You know who I'm talking about, Ben?
Yep.
So
well,
if you
I would like to add on that real quick, Dan. What you're talking about was not at the expense of tenants. It's not like the tenants were being overcharged.
No, it's not at all.
You can dive into the details if you want, but it's simply the verbiage wasn't exactly correct. Nobody was injured, nobody was hurt, and yet it cost
literally millions of dollars in litigation.
Yeah,
from wording, not from somebody paying more than they should. Wording.
Yep.
So take a class.
Yeah. So everybody here feels super confident in getting those rents raised and exactly how to do that, and I love that. Dan and I are working on a new webinar we're going to do called The Science and Secrets of Raising Rents. And it's not just going to be step-by-step what you do, but it's going to talk about, you want to keep your tenants there. So you want to raise rents, but you want to raise the rents, but you don't want it to be too much to boot them out. So how do you look at that and keep your tenants, your good quality paying tenants, how do you keep them happy and also offset your liability and also increase your, or maximize your property's value down the road? The number one complaint I get from potential sellers at this moment is I can't get what I want to get because my rents are too low, right? Properties should be selling in the 160 to even 300,000 per unit range, but if you haven't raised your rent in 7 years, you're never going to get there. So we haven't had any, so more details on that webinar is coming up. We haven't had any other questions pop up except Jeff. That is a great comment. He states it is not the end of the moratorium until 2/22, February of next year. All a tenant has to do is submit documentation, even at court. Same drill, so he doesn't feel like the moratorium is over at all. Yes, that is accurate, but it's not at the same. It's not the same level of moratorium that it was 2 months ago. So point well taken, Jeff. We're not out of the woods yet. So anyway, if there's no other questions coming up, Dan and I are going to let you guys go. Thank you so much for joining us on your lunch hour. I really appreciate it. And again, if you've got questions about professional management or about your property's value or where rent should go, we are here to help you in any way possible. We're the value add guys. We're here to add value to whatever it is you need. So I'm not seeing any other questions. Thank you so much, everybody, for joining us. We're going to get this replay link out later today. Dan, if you have anything else to add?
Best of luck, everybody. Thanks for joining us.
All right. Thank you so much, everyone. We'll talk soon.